In international law, state territory is the geographical area that a state controls and has authority over. It is a fundamental concept that defines the rights and responsibilities of states. Elements of state territory. 1. Territorial sovereignty. The right of a state to govern, legislate, and enforce laws within its territory. 2. Territorial integrity. The idea that a state's territorial boundaries are inviolable. And 3. Territorial jurisdiction. The authority of a state to apply its laws within its territory. Examples of state territory. Land, rivers, lakes, islands, internal or international waters, territorial space, and airspace. Modes of acquiring territory. Occupation. When a foreign state acquires control over an uncontrolled territory. Prescription. Similar to occupation, but concerns otherwise empty territory. Natural changes to state territory. 1. Accretion. Natural geographical mechanisms that increase or decrease the territory. 2. Volcanic activity. The formation of new land due to volcanic activity. And 3. Drying up of a lake. The formation of new land due to the drying up of a lake. In international law, the modes of acquiring state territory are accretion, cession, occupation, prescription, and conquest. These modes are based on Roman law rules for private land acquisition. Accretion. A state's territory increases due to natural processes, such as volcanic eruptions or river deposits. Cession. A nation voluntarily gives up territory to another nation, usually through a treaty or sale. Occupation. A state takes over a territory that doesn't belong to another state. This can be done by raising a flag or making a formal declaration. Prescription. A state acquires sovereignty over a territory through continuous and undisturbed exercise of sovereignty over it. Conquest. A state takes land through the use of force. Annexation. A state takes land, often through some degree of coercion. Original and derivative titles. Original titles are acquired in territories that are legally considered terrae Nullius. Derivative titles are acquired in territories that are already under the sovereignty of another state. Practical relevance. 1. These modes of acquisition are not always relevant in modern practice. 2. International tribunals have not always used these modes in a fixed way. And 3. The issue of territorial sovereignty is complex and cannot usually be attributed to a single mode of acquisition.